Hey, Chip.
Hey, I thought we were taking today off for a sec.
No, I confirmed with Jamie. She should be dialing in soon.
Oh, okay, cool. I'm glad she's coming on because I have nothing prepared. Ugh.
Yeah, I'll send you an updated schedule. We've got guests for the next 3 weeks lined up.
Yeah, I know the next two. We got Mark next week, and then we got Steve in 2 weeks.
Right. And the week after that, we've got a woman, Priya Grove. She's an organizer and declutterer.
Oh, cool. Maybe she can do it from my desk. Did you get any weather yet down there today?
No, it was cloudy, then it was sunny. Now it's cloudy again, but we haven't actually gotten any rain.
Yeah, I heard a little bit of rumbles about 10, 15 minutes ago, but they seem to have stopped.
It's Jamie. I'm on.
Hey,
Hi,
Jamie.
So this phone that I'm on sometimes is unreliable in terms of the internet connection. So if there's a problem, I'm going to have to call back on my cell phone. But it seems to have been okay today so far.
Are you really in Stamford right now?
No, they couldn't get an 860 number for me.
Oh,
So
okay.
I have a 203 number.
There you go. The whole state used to be 203.
I know. I'm classic.
Yep.
There you go. Yeah, actually, our family business was in Cheshire, and that was right on the line to stay at 203 when they went to the 860s. So we didn't have to change our number.
Nice.
All right. All right, so Jamie, we'll start it off. I do an intro, Chip and do some small talk. We'll introduce you, and then we'll just do it as a conversation.
Sounds good. And so this goes for how long?
Half an hour.
Half an hour. Okay. Sounds good.
All right. Hello, and welcome to the Success Showcase. I'm your host, Eric Lopkin from the Modern Observer Group. With me, as always, is Chip Janiszewski from the Happiness and Success GPS. Chip, how you doing this week?
Doing great. How about you, Eric?
Doing fantastic. Summer's underway, and as we record this, we're heading into what will be the July 4th weekend. Any special plans?
Well, actually, July is a fun month for me because my 42nd anniversary happens to be on the 1st. It's really easy for me because all I have to do is remember the month and I get the anniversary right. But yeah, my wife and I are going to be actually going out to dinner for the first time at the Delamar, the outdoor restaurant on Wednesday, and then we get to see our grandchild on Friday. So life is good.
Fantastic. Well, we've got a special guest with us. With us is Jamie Sternberg, an intellectual property attorney. And we're going to be talking about what intellectual property is, why it's important for your business. And Jamie, welcome.
It's great to be here. Thanks for having me, Eric and Chip.
Jamie, why don't you tell our audience a little bit about yourself?
Sure. I am a trademark and copyright attorney. I practice with Saunders and Silverstein. They're based out of Massachusetts, but I am here in Simsbury, Connecticut, and working remotely most of the time. I've been practicing for 15 years in this area of the law and knew that I wanted to go to law school to study it. So this has really been a 20-year passion for me in this area of the law. and I help clients register trademarks with the U.S. Patent and Trademark Office, clear trademarks for use and registration, and defend clients against demand letters, and I also help send demand letters for trademark infringement. So that, in a nutshell, is what my daily practice consists of.
All right, so why don't we start off? I'm sure at least some of our audiences had this question. What is the difference between copyrights and trademarks?
Sure. A trademark is a brand name, logo, or slogan that you use in connection with a product or a service or in connection with a business. And it helps to distinguish your company's products or services from a competitor's products or services. And a trademark has to be used in commerce in connection with a sale or a transfer of a product or service in commerce. And they can be registered with the U.S. Patent and Trademark Office. A copyright is a work of authorship, like a book, or it's also a work of art, like a painting, or it could also be a musical work, like a musical recording, a piece of music. It can be a computer program, a database. So anything really that's a work of authorship. It doesn't have to be used in connection with the sale or transfer of a product or service in commerce. It's just a work of art. They can be registered with the U.S. Copyright Office, and they must be registered with the U.S. Copyright Office in order to actually enforce a copyright infringement action. While copyright develops based on when a product is created, and it can be enforced on that ground, it cannot be enforced unless it is registered, whereas a trademark can be enforced whether it's registered or not.
All right, and trademarks are industry specific. And by that, I mean, I'll use the example of Apple. Apple Computer had the Apple trademark for computers and electronics, whereas Apple Music was a trademark of the Beatles for their recording label. So several people can have the same trademark as long as they're not using it in the same industry, correct?
That depends how famous a trademark is or is not. I would say, for example, Coke was the first one to really have the mark for a caffeinated beverage. And they can, unless there was someone else who concurrently used a Coke mark for something different, or someone who had prior rights to Coke in a Coke mark for something different, Coke can prevent anyone from using Coke in connection with any other good or service, Coca-Cola, etc., because their mark, and I'm not sure that there is a court decision deciding this, but it's generally recognized that Coke or Coca-Cola is a famous trademark. And so they have the ability under the U.S. Trademark Act to stop anyone from using their mark for any good or service because it is famous. If a mark, for example, is not, another example, and actually an example of marks that are possibly considered famous and they are used for coexisting products is Delta. Delta Airlines, Delta for faucets. Both arguably famous for airlines and faucets, and they can coexist because, and they may even have a coexistence agreement among them because they are the same mark and both are very well known. So in that case, I'm not sure when the use started on behalf of either one of those parties, but most likely now, between the two of them, they can probably get anyone using Delta for any other good or service to stop using it, and especially for the products that they have. But in general, if a mark is not famous, then it can be used for different goods and services as long as they are different enough. Yes.
That makes a lot of sense because I mean, who would want to use the name Coke anyway? Because they'd be confused right off the bat with Coca-Cola. So makes a lot of sense.
Exactly, and you'd probably get a cease and desist letter.
So, why should a small business look into trademarking their intellectual property? What are the benefits for a small business?
Sure. So, as soon as a brand name, logo, or slogan or other trademark is used in connection with a product or a service, the owner of that trademark has enforceable trademark rights. They start having rights where they could send a demand letter to someone and say, I've already started using this mark for this beverage, and you can't use that same mark for this, for example, a beer in the same geographic area. But those rights, those what are called common law rights, because say that use, you haven't registered your rights for that use yet. Those are called common law trademark rights. Those rights are limited geographically to where the trademark owner has built goodwill with consumers, to where they've directed advertisements. Even if you have a website that anyone can be seen anywhere in the world, you might be limited to where you've intentionally directed advertising in terms of where your common law enforceable trademark rights exist. Now, if you file an application with the U.S. Trademark Office to get a registration provides many benefits, including that you have rights to use the mark nationwide, and so it's a lot easier to expand your business. And it's a legal presumption that you own the mark, that the mark is not deemed descriptive, and that there is no other registered or pending applications or registrations that are confusingly similar to your mark. Basically meaning that they're not the same as or very similar to your mark for the same or similar goods. A registration also deters others from adopting or registering a similar mark to yours for similar goods and services. It can be used as a basis for registration if you do business in other countries. You have the right to use the R in a circle symbol, whereas if you're just relying on common law trademark rights, you can use a TM or SM, but you can't use the R in a circle symbol. You can also record your trademark with U.S. Customs and Border Protection in order to prevent counterfeit goods from coming into the U.S. There's additional causes of action available to you in terms of trademark infringement, and it makes litigation and enforcement of your trademark a lot less expensive, because you're not just with common law rights, you have to show your geographic scope of consumer goodwill, and you may have to demonstrate that your mark isn't descriptive, for example. All of that's already taken care of with the trademark registration. It also makes your business more attractive in terms of people who might be looking to buy your business, or if you want to try to license products, licensees are going to look to see whether your trademark is registered.
All right, so for a small business, what kinds of items can be trademarked?
You can, if the business is, say it only provides services, and they use a brand name or logo on their home page of a website and other pages of the website potentially, they can register the brand name in standard characters covering any use of that brand name in any stylization or with any designs for the services that they provide. So if it's a website for someone providing business coaching services, we would file the trademark to identify business coaching services. And we would use you have to provide a specimen of use. We would use a screenshot of the website in connection with the mark showing the description of the services. If it was a business owner who has a product, like a new beer product, for example, the trademark application would be potentially for, and this is also true for the business coaching services, for it could be either for the brand name or the logo, used in or both, used in association with the beer. So we would submit, you'd have to submit a specimen of the use with the U.S. Trademark Office. We would submit, for example, the label for the beer showing the brand name and the logo.
I would imagine some businesses are leery about the pricing of your services versus doing things themselves. I mean, I know that you can probably go online and look up how to get yourself trademarked and copyrighted and so on and so forth. And obviously, there's a lot of due diligence that has to be done. So can you shed a little light on that as far as how easy it is for people to kind of look at it themselves? And then also, are there misconceptions about how much it costs to use somebody like you to get a trademark or a copyright?
Sure. The U.S. U.S. Patent and Trademark Office website does have information for like a lot of frequently asked questions and user guides in order to file a trademark application yourself. And there are, lower cost services like LegalZoom. But the benefit of using a trademark attorney is that you're going to get someone who has done this over and over and over again. We've responded to what's called office actions that are issued from the U.S. Patent and Trademark Office. We've overcome, issues that have come up. In terms of me and my 15 years of experience, I've basically seen everything, and I kind of know my way around the system. And my one goal when filing an application for a client is that they get through the application and registration process as smoothly and as quickly and as economically as possible. If you do it yourself, you're going to have to be able to know how to what to put in the application to make sure that you cover all of the goods and services that you're offering to kind of, an attorney will be thinking about that in terms of the U.S. Patent and Trademark Office Identification Manual. We're going to know how to state things the way they need to be stated to fall under the goods and services description in that manual. We're going to know to do it in such a way as to protect your assets to the fullest to make sure you can enforce them, and you want to make sure your goods and services are broadly written, but not broadly written so much so that you get a refusal from the U.S. Patent and Trademark Office. So when a trademark attorney sort of knows how to navigate that, and I'm such a nerd, I love writing descriptions of goods and services. You basically need to say the same thing over and over again in different words to make sure you're covered in all sorts of bases. An attorney will also know whether there is a potentially conflicting mark that was previously filed to your mark and could be an obstacle to your mark, and can write the goods and services description in such a way as to avoid a refusal by the U.S. Patent and Trademark Office based on that mark. If you do it on your own, you may confront that issue. You may confront an issue where you have to amend the goods and services and you're not really sure what they're asking, so you have to hire a trademark attorney anyway. The trademark attorney can help docket deadlines and help interpret correspondence received from the U.S. Patent and Trademark Office. As well, a trademark attorney can help interpret the results of a trademark search. Say you do your own trademark search using Google and you're not sure whether something is a conflict or not. Most times it's actually not a conflict because something comes up that's the same name as yours and you think that's a conflict, but it's not actually, because it's, it's two different goods and services. And it's worth having a trademark attorney do the initial clearance search, because if you just rely on Google yourself or you don't do a clearance search at all, you could be a year into your business and get a demand letter and have to rebrand, which is actually more expensive than initially hiring an attorney to do the clearance search and make sure that your mark is clear to be used in connection with the good or service that you want to be using it for.
Yeah, I know that there's a timetable for all this to happen from the time that you originally do the searching and submit and so on and so forth. Do you want to go over that with us as far as how long it usually takes?
So if We generally either do what's called a preliminary search or a full search. A preliminary search is just where the attorney will do an exact or nearly exact mark search using the U.S. Patent and Trademark Office online database and Google. And to do that is just a matter of 1 to 3 days, for example, turnaround time. If you do a full search, it takes about 3 or 4 days. No, actually, it takes about 2 or 3 days to get the results. We have a vendor put together a search report, a more complex search of the U.S. Patent and Trademark Office, state trademark registries, business names, common law trademarks, domain names, and a search of the internet. That all gets put together in a search report, and it gives trademark owners a very good idea of what's out there that may or may not conflict with their marks and what the risks may be. And so that takes about 2 or 3 days to get the report, and about maybe depending on how fast the client needs it, could take about a week or less to get the results back to them, because usually we'll do those results in writing. And then when we file the trademark application, we try to file applications as soon as we get the instructions, because you want to have the earliest filing date possible. And it usually takes about 3 months for that application to get examined by an attorney at the U.S. Patent and Trademark Office. And then if any issues are raised, there's 6 months to respond to an office action that the examining attorney may issue. And then once you sort of get through that prosecution period, the application's published for opposition for 30 days, where a third party may object to the registration of that mark if they think your mark is too close to their mark, for example. And then if you get through the publication period, the mark gets registered about a month after that. So if you're using a mark in commerce, when you file the application, it could take less than a year to do that. If you're not using it in commerce and there's some issues, it could take potentially up to about 3.5 years, depending on when you start using your mark in commerce, because you need that in order to get a trademark registration. You have to demonstrate that use in commerce.
Obviously, we're getting a lot of information here for those of you out there. I'm sure there's a lot of single person businesses and smaller businesses that try to do this themselves. But with what you've just explained to us, I'm saying to you, small business owners, time is money. And it sounds like you could put a whole lot more time into this, not working on your business, just trying to save a few bucks working with somebody like you. And I imagine you run into that a lot as far as people saying, why should I use you? But to me, that's one of the main things that you're going to be able to do as professionals do. And that's basically, you're obviously an expert at what you do. And it's not just as easy as looking something up and saying, oh, nobody's got it and I'm going to get it.
Exactly. I mean, and I do confront that a lot. And a lot of times the people who decide to go forward with using us are people who have done this before. They've started a small business before and they were burned, for example, or they worked at a bigger company and they kind of already know the process. It's sort of educating maybe people who this is the first business they've started, and in their last position they weren't familiar with this process, and they're just not they're just sort of learning what they need to do to get the business started. And I think that after you form your business, the entity, which is called a trade name or a business name, and that's different from a trademark. That's the name, that's the company for which you're going to be operating. That may not be the actual name that's on the homepage of your website, for example. That's what the trademark is. Once you form a business, the second thing, and maybe even before that, the first thing you need to do is potentially looking to see whether your name is even available. So it's like forming the business and looking at the availability of names and the availability of marks is really the first thing that you need to be thinking about. And even if you don't do that first and you've been a year or two into your business, you can still, or even 30 years into your business, you can still think about trademark registration. There's still benefits to doing it.
you were talking about use in commerce. And I'd like to talk a little bit about that because you do have to protect a trademark after you get it. And examples of this are Kleenex, Frisbee, and Xerox, all of which had to defend against their name becoming generic.
Yes. You need to, once you get a registration, you need to think about a few things. One being that you're going to need to file what's called a declaration of use between the 5th and 6th year after registration. So in order to do that, you need to be consistently using your trademark, the one that you got registered, for the goods and services that you got registered, or at least some of them. The ones that you're not using between the 5th and 6th year, you can delete. So you need to sort of think about that consistency that you have in your trademark. You need to think about setting up a trademark watch to see whether there's anyone else who's possibly adopted a mark similar to yours or is looking to register a mark similar to yours. You can just be aware of what's out there and enforce your rights, because if you're not looking to see what's out there, you can lose your trademark rights that way. It could be deemed potentially an abandonment of your rights, or your mark could get diluted by other users. So dilution is a serious thing to think about if you're not sort of doing your Google searches or hiring a watch service, which your trademark attorney can institute. And then another thing, of course, is not letting your mark become generic. And the best way to do that is always to use a noun after your trademark. So say the trademark is Green Mountain Beer. You always want to use that term after your mark. So, or Kleenex and Velcro have set up campaigns where they are training people to always say Kleenex brand tissues or Velcro hook and loop, or Velcro brand hook and loop. I don't know. It's something similar to that. So you have to see how consumers are using your mark and kind of make sure that they're not genericizing it. For example, if you are the first person to have ever come up with a name, this product, and it's a unique name for it, you have to make sure that people aren't out there saying, I'm going to go Google this, or can you hand me a Kleenex or some chapstick? You're training people how to use it correctly by either following it with a noun or with the word brand in a noun.
It's interesting. Now, for a small business, how onerous are these requirements to keep a trademark?
I mean, you just want to be periodically doing Google searches. I mean, ideally, you want to have your trademark attorney have a watch service, and watch services are not expensive. It's like $300 or $400 a year for either you or your trademark attorney to have the same vendor who generates these full search reports that I talked about conduct these watches to see what applications for trademarks people are filing. Or there's also services, watch services related to the internet. So just to keep an eye out on what's going on. It's not, I wouldn't say it's an onerous burden, but if you do see something that really you really need to send a demand letter on, but yet there's 10 other people using the same trademark for the same or similar goods, the person you're sending a demand letter to is going to bring that up and say, well, if they can all use your mark for this, then I should be able to too. And if you're not out there kind of making sure that's not happening, that's the result that you're going to get.
All right. Chip, do you have any more questions?
I've learned a whole lot today, and I'm just saying that people need to use Jamie for doing these type of things. I know that Jamie, you actually started putting together Zoom information sessions and so on and so forth, which is probably a really, really good thing for a lot of people to be listening out there. So you want to give yourself a little plug on exactly when you have these things coming up and how those work, because I think that it's very, very important for business people to understand what's going on here.
I don't actually have any dates currently scheduled. I just did one last Thursday, and I think my next one is going to be actually through the Avon Chamber of Commerce, hopefully sometime this month. So the best way for people to kind of keep updated on what I'm doing is to follow me on LinkedIn. I will always, or follow our law firm on Facebook, and on LinkedIn, I'm Jamie Sternberg, or Jamie Platkin Sternberg, or you can also follow Saunders and Silverstein on LinkedIn or Facebook, and we will definitely be posting their information on my next free Zoom session.
Great. So, Chip, what do you think is the big takeaway from all of this?
The bottom line is you can't be an expert at anything and everything in the bottom. So when it comes to something like this, you really need to know what you're doing. And I think for the cost of using Jamie, it's going to save you a whole lot of headaches, and you're going to get it done absolutely correct, because there's a lot of different things that need to be done in this. Number one, to get things, and then, as Jamie mentioned, to stay in compliance and hang on to what you fought so hard for in the first place, moving ahead.
Exactly.
Absolutely. I think the big takeaway is you're putting a lot of time and effort into building your business. You also need to put the time and effort into protect your business. And trademarks are a great way to do that. And that's not your core competency as a business owner. So yes, reach out to an expert for it. You've been listening to the Success Showcase. You can catch us every week at xvadio.com/podcast. You can also find us on the Apple Podcast app, Google Play, iHeartRadio, Spotify, and wherever you find podcasts. Remember, make this your best week ever, and make next week even better. See you then.